Hi, this is Terry, and I'm doing my final project for our electronic media law and regulation class, and it's titled, Is Your Dance Move Protected by Copyright Law? An overview, we're going to talk a little bit about copyright law, the history, and kind of where it is today. And then I'm going to tell you about the different individuals who are involved in my cases, the first being Epic Games. They're defendant in all the cases. And then there are several plaintiffs in a few cases, the cases that I'm presenting. So Terrence Ferguson, he has 2 milli. He's a rapper. Alfonso Ribeiro, he played Carlton Banks in Fresh Prince of Bel-Air. He also has suit against Epic Games. Third person is Anita Red on behalf of her minor child, who is also known as the Backpack Kid. And then finally, Rachel McCumbers, who is suing Epic Games on behalf of her minor child. We don't have his actual name, but he is also known as the Orange Shirt Kid. And then finally, I will wrap up the presentation with a conversation about a case that went to the Supreme Court between Fourth Estate Public Benefit Corporation and wallstreet.com, and kind of tie that all together for you. So copyright law, I've got a lot of history on it, so I'm really just going to breeze over some of this. It started back in when we were still just colonies. We were following what was called the Statute of Anne, which was Queen Anne of England. And at that time in 1783, a little after that, someone smart in Congress said that nothing is more properly a man's own than the fruit of his study, and that the protection and security of literary property would greatly tend to encourage genius and promote useful discoveries. Unfortunately, at the time, the Continental Congress didn't have the power to enact laws like copyright laws. So in the Constitutional Convention in 1787, some people like James Madison were lobbying for this. And President George Washington in 1790 said, hey, yeah, I think I agree. I think we should have some laws that will help protect people's literary property. They produced the the Copyright Act of 1790, and it was actually printed in its entirety in the Columbian Sentinel newspaper prior to 1976. So early on, copyright term was 14 years, and if the author or the creator of whatever the copyrighted work was lived through that first term, they were eligible to apply for another 14-year copyright term. After that, whatever it was became public domain. So I've got a lot of years listed. So 1790, they re-ratified the Copyright Act. So in 1790, that Copyright Act covered books and maps and charts. And in 1802, they added etchings to that. They also added or began with some statutory requirements for actually applying for copyright. Those are things like submitting the application, paying a fee, putting out copyright notices so that people knew that you own a copyright. Through the years, there were several times that the Copyright Act was re-ratified. So in 1831, and between 1831 and 1870, there were 9 amendments, again, changing the term, adding musical compositions, photographs, and some changes to the statutory requirements. 1870, between 1870 and 1909, there were 14 different amendments. They added paintings and drawings, allowed dramatizations and translations of literary works to be copyrighted. Until 1891, all of this still was taking place in the United States. 1891, the International Copyright Act came into being. Then people like Charles Dickens, who got upset because, those Yankees in America were creating cheap little copies of his literary works, he could be happy now that there was some international copyright protecting him. 1909, they changed the term to 28 years, and then a renewal of 28 years. They also added motion pictures and films in an amendment in 1912. So 67 years later, the Copyright Act of 1976 had a total overhaul. They listed basic rights of copyright holders. They defined the fair use doctrine. They changed the term to the life of the creator or author plus 50 years. And then in 1998, the Copyright Term Extension Act actually changed that to plus 75 years before public domain. They began requiring a signed document of intent in order to transfer copyright. And this is the first time when copyright protection could be given to original works that are fixed in a tangible medium of expression. So they didn't actually have to be published. It just had to be fixed in some way that it would be able to be kept and then be able to be expressed or shown to other individuals. So this is broadening the scope of the federal statutory copyright protection from published works to works that are just fit. Registration with the Copyright Office is not a prerequisite for copyright protection, but Section 411 of the Act does require registration before a copyright infringement action by the creator of the work can proceed. So that's important to the few cases that I'm going to talk about in just a minute. What can you copyright? And that's a big question. So works of authorship that are fixed, I've already said this, intangible medium of expression that could be a form now known or something that can be developed later on, which can be perceived, reproduced, or otherwise communicated either directly or with some machine or device. So this is things like literary works, musical works with the lyrics, dramatic works with music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and finally in 1990, architectural works. What can you not copyright? In no case does copyright protection extend to original work of authorship in any of these areas. Ideas, procedures, processes, systems, methods of operation, concept, principle, common known information, like is the sky blue and is rain wet, or rain is wet. Choreographic works that have not been recorded or notated. Names, titles, short phrases, expressions, product descriptions, pseudonyms, titles of work, business names, although some of those can be trademarked, regardless of the form that it's in or which describes, explains it, illustrates it, or embodies the work. These things cannot be copyright protected. So what are the cases about? Well, Epic Games is an American video game company and software development company based in Cary, North Carolina. Tim Sweeney is the founder and CEO, and they developed the Unreal Engine, which is a software development environment that's used by them and then by other video game makers to build video games. They have also developed several successful games, including Fortnite, Gears of War, Infinite Blade, Shadow, and Bulletstorm. They are a multi-billion-dollar company, and they are held by Sweeney and Tencent, which is a Chinese multinational investment conglomerate. So what is Fortnite? Because this is important to our cases. So Fortnite is a video game. It's an online video game that millions of people play. It was released in 2017. There are actually 3 versions of it, but Battle Royale is the one that has become an online cultural phenomenon. It has provided significant financial success for the Epic Games conglomerate. Several celebrities and athletes talk about playing Fortnite. There are lots of different types of Fortnite challenges that you can find online. So you see my picture there. These are different people's different characters, and they can dress in different types of clothing or different types of skins, and they can either win in the game or they can buy actions for their characters to do that are called emotes. So, some can wave, or you can do the, loser sign, or different kinds of dances. And that's what these cases are going to be about. Why is Fortnite so important? Because Fortnite is huge. Within 2 weeks of its release, 10 million plus players were playing online in this game. And then by June 2018, just after the Nintendo Switch came out, they had reached 125 million players. Revenue during the first half of 2018 was estimated in the hundreds of millions of dollars per month, with a total 2018 revenue of $2.4 billion. Now, who wouldn't want a piece of that? All of these people do. So Terrence Ferguson, who's also known as 2 Milli, he is an American rapper. He is suing Epic Games, but he claims that they have inappropriately used his dance, the Milli Rock, and they have renamed it as Swipe It, and they call it theirs, and they put it in their video game with no permission or to him and no compensation. Alfonso Ribeiro, he has a dance called The Carlton. He performed it in his TV show many years ago, Fresh Prince of Bel-Air, and he's also performed it on ABC's Dancing with the Stars. Claims this is a dance he made up himself, and that Epic Games and Fortnite have put it in their game without compensation and without permission from him to do so. The third group, Anita Red, for the Backpack Kid. Again, we've got a mom claiming copyright infringement and trademark infringement for her minor child who does a dance called The Floss and claims it to be his own. Rachel McCumbers, on behalf of her son, the Orange Shirt Kid. Same thing. He has a game. He has a dance of his own called The Random, and he has a little catchphrase. And they are claiming that copyright and trademark infringement from Epic Games for using it in their game. Finally, I'm going to wrap all this up pretty quickly with some information on the case between Fourth Estate Public Benefit Corporation and WallStreet.com. And this is a case which was argued in January of 2019, and it was only just decided in the opinion of the Supreme Court was given in March of 2019. And one more small fact about for the first 4 cases, all of these plaintiffs have the same attorney group. They have Pierce, Bainbridge, Beck, Price, and Het of Los Angeles, California, are representing these 4 plaintiffs in their suits against Epic Games. Okay, so the first I'm going to talk to you about Millie Rock. So Terrence Ferguson, he is claiming he created Millie Rock in 2011. Recorded it on a video, posted it on YouTube. That's your required fixed and intangible medium. And so this is his little dance, and you can't dance it. You can't put it in your video game. So don't swipe my Millie Rock. Unfortunately, he didn't register the dance. It's just a few dance steps for copyright protection. And Militant Rock, which is the video that his Millie Rock is in, actually didn't publish on, wasn't posted on the internet or YouTube until 2015. And since then, and since these cases have taken place, it actually has over 19 million views. I'm going to show you a really quick clip of Millie Rock. I'm going to skip into it because they don't do it for a long time. Okay, if I can get you to go. Fellows are getting together.
We ride around in the streets.
That's not Millie Rock.
Strapped
That's
up.
not Millie Rock.
We hop out on any block.
Doing it yet. That's not it either. This isn't it either.
I'm Millie Rock on any block.
Okay, it's going to start doing it here.
I'm Millie Rock on any block. I'm Millie Rock on any block.
Don't want to miss it. Oh, here we go.
I'm Millie Rock on any block. I'm Millie Rock on any
so this young
block.
man has the Millie Rock.
I'm Millie Rock on any block.
Epic Games just put it
I'm
in
Millie
their
Rock on
video
any
game.
block.
He is not being compensated for swiping his hands and taking a couple steps sideways. Okay, so that is the Millie Rock. As plaintiff, he is, and I've got one of these little clip snippets from the actual complaint of each of the plaintiffs, just to show you how, like I said, they all have the same attorneys, and then they all have practically the same complaint against Epic Games. So suing Epic Games because they capitalized on the Millie Rock's popularity, particularly with younger fans, by selling Millie Rock as Swipe It, which is the name of the emote in the video game, but did not credit or compensate Ferguson or seek his permission to use it. Lawsuit does not commit to a specific figure, but seeks actual and punitive damages, legal fees, and further relief as the court may deem proper, as well as a restraining order preventing Epic from using, selling, or displaying the Swipe It emote. So, and that's the case with most of these cases. They want actual and punitive damages, legal fees, and they're trying to get an injunction against Epic to keep them from being able to use their dance or sell it or display it or anything like that. Okay, so that is to Millie. I'll show you a little clip. So Epic Games, this will be their the actual like a character in the game doing the Swipe It. So there it is, little game character, swiping his hands around. Not exactly what the guy in the video was doing, but you can kind of say it's close. He's not taking steps sideways, he's shifting his hips. I'm not the defense attorney, so I'm just not necessarily the same. So Epic Games, in their defense, they have actually submitted a memorandum in support of their motion to dismiss the case entirely, pursuant to a federal rule that allows dismissal of lawsuits that fail to state a claim for which relief can be granted. They have also submitted a special motion to strike the plaintiff's Second Amendment complaint pursuant to California Code of Civil Procedure 425.16, which is California's anti-SLAPP law. So when the plaintiff's attorneys found out that Epic Games attorneys were going to submit a motion to dismiss the case, they said, hey, let us take our complaint back. We need to make some amendments. Let's slow the roll on this. So let's try to make it stall for a little bit. And Epic Games said, attorney stepped up and said, oh, no, we're going to anti-slap law this. So Epic is also contending that there's nothing to be copyright protected because the Millie Rock is a short dance routine consisting of only a few movements or steps. It's not copyrightable according to the Compendium of United States Copyright Office procedures. They have, if you read through the actual response to the complaint, they have just loads and loads of defense items in that document. So a little bit of review about what the plaintiff has to do to prove infringement. So plaintiff must establish ownership of valid copyright. And I've already told you that Ferguson actually didn't file for copyright or didn't apply or get one. So he doesn't have that going for him. Number two, actionable copying by the defendant of constituent elements of the work that are original. So number two is the work has to show originality to begin with. There's no evidence of factual copying, and the defendant holds that there are no original components of the plaintiff's dance step, which in and of itself is no more than an idea, and ideas are not copyrightable, so it's not protectable. Without proof of factual copying, to show the defendant, they have to show the defendant had access, and there's no argument about that. Everybody's seen it on the internet. We know that there's access without doubt. So then they also have to prove substantial similarity. The defense, Epic Games, believes that the plaintiff has no grounds for similarity. Okay, because what's going to happen is they have to identify and filter the actual created work. So the Millie Rock, they have to remove the unprotectable elements and then consider what they've got as a whole. Well, they don't have any protectable elements to begin with. According to the defense, the dance steps, the Millie Rock, it's not protectable at all. And as an idea, the case should just be dismissed to begin with. Okay, so let's watch Carlton, Alfonso, whatever his last name is, and I'll show you a little clip of his dance, 3 simple dance moves. Here's Fred from Fortnite Battle Royale.
It's not unusual to be mad with everyone. It's not unusual to be sad with anyone.
Dancing with the Stars. Okay, so get out of that and move on to the next. So as a plaintiff, he's claiming that Epic Games took his dance to Carlton, didn't ask his permission, haven't compensated him for it. You can see he has a list of complaints: direct infringement, contributory infringement, violation of right of publicity, violation of right of publicity, unfair competition. He filed this claim in December 2018, same attorneys. And then he went to the Copyright Office and said, hey, I need to get this copyrighted. Well, the version, so he submitted 3 versions, and I showed you one of them, the one that he got from ABC's Dancing with the Stars. Copyright Office didn't outright reject that one, but they didn't issue a copyright because they're still trying to gather further information to determine who actually would own the copyright to that, because they don't think he would. They think the producers or owners of the show actually own the material that's done on the show, which would be the same case with the version that was produced in Fresh Prince of Bel-Air. He wouldn't actually own the copyright to that. It would be owned by the producers of the television show. And so there was a letter directly from the Copyright Office where they refused to register his Carlton dance. And the reason why was it's a simple routine made up of 3 dance steps, and they refused registration. So Epic Games has hundreds of these emotes, different kinds of dance steps, different moves. You can go on the internet and on YouTube and see just hundreds of challenges where boyfriend challenges girlfriend, who can do the best swipe it, who can do the best shoot dance, who can do the best tidy, whatever the move is. So it's a social thing. People go on the internet, they do these dances, they do these dance challenges, and these are things that can't be copyrighted. So next, let's talk about the Backpack Kid. So the Backpack Kid is this kid who does a dance called the Floss, and he was in a music video with Katy Perry, and he was on Saturday Night Live with Katy Perry, and his mom is now suing Epic Games because Fortnite uses the Floss in their video game. So, and one of the reasons why they are suing for these things too is Fortnite, Epic Games does make money off of these, because in some cases the player actually has to buy a battle pass or has to spend so many V-Bucks in order to purchase an in-game skin or in-game clothing, or to buy one of these emotes to use on their character. So back to the Backpack Kid. So you're going to see he came around, 2018, made this video with Katy Perry and got popular. And so he was on Saturday Night Live with her doing the floss. Well, as I was researching this, I'm out there and I'm looking for, okay, show me people doing the floss. Well, look, I found a guy in 2014 and he doesn't call it the floss. He just walks around. His name's Justin Stewart, and he's just walking around. He says, hey, look what I can do. So he's walking around in the library, college kid someplace. And he's one of those kind of weird kids, got nothing else to do, I guess. Recordings to have to do.
What do you say?
I don't see the backpack head standing around there.
Thank you, guys. Okay.
Not a one-time thing.
Look what I can do.
Okay, end of Justin. So you see, he's been doing this for a long time, since November 2014 at least, and he's got almost 5 million views. What's to say that some of those might have come along because of these cases. But here's the Backpack Kid as a plaintiff. Again, he's got all of these different complaints. They're not any different from the other guys. Direct infringement, contributory infringement, violation of right of publicity. He did add for his case in Orange Shirt Kid, they did add trademark infringement because their mothers are claiming they are child performers. They worked very hard to get where they are at. Now, Backpack Kid has done a little bit more than Orange Shirt Kid, but that using their likeness, which is their dance in a video game, dilutes their trademark, and might threaten their market value. So yeah, I'm not too sure about that. Might actually get them out there and get them seen. So here's a Backpack Kid. So Backpack Kid goes online and he judges Fortnite challenge dances. I think we got a little bit of I don't understand how we go from.
Okay, so that's Jimmy right there.
He's not doing this.
He's the only one doing it incorrectly.
He's watching people on Jimmy Fallon show. And now he's going to judge.
It was good job, Backpack Kid here. You probably know me for doing the floss. Alright, so I did that dance a couple of years ago. It started blowing up on the internet. And then season 3 of Fortnite, it went into the game.
And there it is.
Ever since they put it in the game, the dance has gotten bigger and bigger ever since. So it's pretty cool that they put it in. Alright, so today I'm going to watch some videos of people doing the floss and I'm going to critique them. Alright, first video we have is Fortnite Dance Challenge in real life. Boyfriend versus...
My dance. He just mentioned the dance. Let's move on to the Orange Shirt Kid. But wait, okay, Orange Shirt Kid, I'm going to talk about why he did his dance and what happened with his dance, but I want to back up a little bit to April of 2017. The internet has all these challenges that go on all the time. Well, back in early 2017, there was what was called the Mask Off, and this was a challenge where people would play this particular rap song called Mask Off, and they would dance to it and challenge each other. So here I'm going to do a video of myself with Mask Off, and then they'd put it on the internet and they'd challenge somebody else to do the same thing, do a dance, or play your violin or play your cello. A lot of musical instruments playing, classical music to the rap song Mask Off. Anyway, so these kids are doing this back in early 2017. Just wanted to point out. Just saying. Okay, so I'm going to show you this guy. Take a look at his dance. Okay, hoping it's going to show. Maybe. It didn't get popular from the dance. It got popular from And there's this little girl. I don't know if this one will do. Same thing. She's got the Mask Off challenge. So she's going to do that for us. Get this video to show. Okay, so let's talk about copywriting pantomimes and choreographed dances. So circular number 52 talks to you specifically about how to copyright choreographed works and pantomimes. But it says specifically in this document that categories of dance and movement, there are some that are not protected by copyright. Dance and non-dance movements such as sports activities and performance art do not fall within subject matter protected under Copyright Act, even though they may be unique. Other things which are not copyrightable, common movements or gestures, social dances. We've seen a whole bunch bunch of social dances, ordinary motor activities and athletic movements. If you wanted to spike a ball and go, oh, yay, I spiked the ball, you can't copyright that. Routines not performed by humans, compilations, and derivative choreography, or pantomimes. Not copyrightable. We're getting there, almost to the Orange Shirt Kid. So Orange Shirt Kid, he is a big Fortnite fan, believe it or not. He plays Fortnite all the time. So in Fortnite, or in Twitter, sorry, his handle is Kid Fortnite 12. So back in March of 2018, Fortnite had what's called the Boogie Down contest. And this was a contest where Fortnite fans, the Fortnite community, would go out and they do just like the two kids you just saw. They would record themselves doing some original type of dance, some motion, something that would be cool. And Fortnite was saying, we're going to take the top 100 winners. We're going to give you some great prizes. And the top, however many they decide, we're going to take your movements, your dances, we're going to put them in the game. This little snippet over here on the side with the numbers and the highlighted yellow for Kid Fortnite number 12. Kid Fortnite 12, that's his Twitter video that he submitted to Fortnite's Boogie Down contest. And you know there has to be some fine line rules that say whatever you submit becomes our property, etc. I don't know. I didn't look. But here's Orange Shirt Kid submitting his dance directly to Fortnite for the purpose of having it put in this game. He comes in 23rd. He doesn't win, and he's not in the top 5, which are the people that are going to get put in the game. So he's not going to get put in the game. Well, then a bunch of online folks go, oh my God, Orange Shirt Kid was so great. His dance needs to be in the game. So really it was the fans and the bloggers who watch his video that said, hey, we need to get this kid dance in there. And Fortnite said, okay. And they put his dance in the game. And then his mom sues him. Great. So question is his dance copyrightable? And number 2, is it his dance to begin with? So here is Orange Shirt Kid. And I'll show you a little bit of clip of his video. I'll get it to show. Listen to him.
Thanks, Fortnite. If this actually stays in the game, I'll probably crap my pants. Y'all ready?
Specifically putting it in the game.
This is called the random.
And here's his random. Oh my goodness, he looks like those other 2 kids. The earliest I could find this particular dance posted on the internet.
It's also a great exercise move.
It's also a
great exercise move.
The earliest I could find it posted on the internet was April 12th.
Thanks, Fortnite.
So that's 12 days after they post the announcement that they're having this game. He hashtags it, sends it to Fortnite, and to compete in this game with his little dance. So here's a snippet from his complaint. Same thing: direct infringement, contributory infringement, violation of rights of publicity, unfair competition, trademark infringement. And again, like I said, his parent now has decided he is a child performer, and he's worked very hard to get the reputation that he has. And his catchphrase, it's a good exercise move too, or it's a good exercise move, his catchphrase now. They used it in the game. They used his dance, which is his likeness, without permission or compensation. So my last case that's going to tie all this together for you is Florida State Public Benefit Corporation versus WallStreet.com. And like I told you, this one was decided in March 2019. So a few of the facts on this one. Well, first of all, the issue is copyright registration required before a suit for copyright infringement can be filed? So they're asking the question, can I sue somebody if I don't have copyright registration? That's important to the 4 cases that I've explained to you before. Okay, so the facts in this one, Florida State creates their company that writes articles, news articles, and then they license them out to websites that post news articles. So they gave some articles to WallStreet.com. They put them on their website. After a period of time, the license ran out, and FE or Florida State is suing WallStreet.com because they didn't take them down, and they feel like it's copyright infringement. They don't have license to do it, and Florida State has applied for copyright. They have registered the articles with the Copyright Office. They have applications to register them with the Copyright Office, but the registrar at the time had not done anything with the applications. Now the courts are split over this previously. Whether or not having copyright registration required that the Copyright Office actually grant or deny the certificate of registration, or whether just applying for the certificate would qualify as registration. So 2 approaches: the registration approach, which the 10th and 11th Circuit Courts held that it is considered registered upon the Copyright Office's, upon the copyright's approval by the Copyright Office, and that's the registration approach. And then there's the application approach. Other courts, including the 5th and 9th Circuits, they held that registration requires the application for registration and any fees or deposit and the deposit of the works that's needed for it, and that application approach is enough to say that you've registered. But in many cases, you know, that application could be denied and that person never have a copyright to begin with. So that's where the question comes up. Is a copyright registration required before a suit for copyright can be filed? Okay, so the findings on this. The lower courts, for this case, it was the U.S. District Court in the Southern District of Florida, and they granted WallStreet.com's motion to just dismiss the case because Fourth Estate did not own registrations for the work at issue. So then Fourth Estate took it to the U.S. Court of Appeals in the 11th Circuit, who ruled that the infringement suit couldn't be brought because of a lack of copyright approval. So again, we're going to strike them down again. Well, this was such a big deal that guess what? Surprise, they went to the U.S. Supreme Court. So we want to know, what does RBG have to say about it? Well, Justice Ginsburg delivered a unanimous opinion of the U.S. Supreme Court. The court, they had arguments on January 9th, 2019, and on March 4th, the court held that registration certificate must be provided before a lawsuit can be filed. And the decision applies only to filing copyright litigation. It does not apply to other forms of enforcement, such as takedown notices. So what does all of this have to do with my dance move people versus Epic Game cases? Well, the plaintiff's attorneys, if you remember, they all have the same one, voluntarily withdrew all the cases, as none of the plaintiffs have received copyright approval for their allegedly infringed upon work before filing the case. So, surprise, another case just shot you all down. Okay, so here's a list of my citations. There were a lot more, but here's one slide worth anyway. I hope you learned something from my presentation. I hope you enjoyed it, and I hope you have a fantastic summer. Thanks. Bye-bye.